Hi everyone, I'm Don Smith coming to you from the beautiful Channel 36 studios here in downtown Clark, and today we are here to talk to you about a very important subject, and for a lot of folks it's a difficult subject to talk about. It's going to be wills and estate planning, and joining us once again in the Channel 36 studios is Clark attorney Mitch Beinhaker. Thanks so much for joining us.
Back.
Let's get into about wills and estates. And again, as I mentioned there in the open, it can be difficult for a lot of people because you're planning for the end of your life or your family's life or a family member. Let's start at kind of just the beginnings of what is a will? What constitutes a will, and why is it so important that folks should have them?
Yeah, so, and you're right, a lot of people put off wills. Maybe they're and the spouses can't decide who the guardian of their children are going to be, or they're later in life and they just don't want to face their own mortality. But at the end of the day, if you don't have a will, it gets much more complicated. And we live in a relatively simple probate state. So when it comes to a will is basically your written wishes as to what you would like to do with your assets, who would you like to take care of your minor children, do you need to set up trusts, what other, your final returns, who's going to be the person who handles your estate, all those types of things, right? And there are situations where somebody wrote something down, and if it's in handwriting, it's called a holographic will, and they submit it to the court, and it's the judge to decide, is this really the person's intent? Was this his will, or does he not have a will? If you die without a will, it's called intestate, and the government makes the rules, basically. You don't make your own rules. So,
wow, that's certainly something you do not want to have, I would imagine.
Yeah, that you kind of want to avoid.
That's going to be really difficult.
Yeah, in some states it's just unbelievably difficult. In New Jersey, it's difficult, and either you don't have a will, or you can't find the original will. You may have to file in court in front of a judge to get an order to have whatever you have admitted into probate, and then you start the process. But that's what the will is, and the will appoints the person who's called the executor, or the executrix if it's a female, and they file the will in court, and that starts the whole process of transferring assets, appointing guardians, creating trusts, paying final bills, dealing with creditors, all those types of things. Getting releases from the beneficiaries, notifying people, you have to publish things in the newspaper, stuff like that.
Yeah, and for many, they probably either only hear of a will, let's say either, depending on your age, obviously, either your grandparents or honestly from TV. You know, you always see these big scenes of, these big families fighting over the will, and you see the lawyer walk in.
Don't have to be big families to fight.
Bobby has left this umbrella for you, and it's like, okay, well, the umbrella.
Or I've intentionally left Bobby nothing.
Exactly, that's right.
I have people want to put that in their will, tell why their children are being left out of the will, and I'm like, don't put that in.
Don't want to put that in, exactly. So again, it's really important to get your affairs in order now, where you're sound body and mind and so forth, and you can set these things up prior to the final days, or if something happens, So, and it's it's really important.
And don't think I haven't rushed to the hospital before to deal with things like that.
Well, I can imagine.
Sometimes I don't make it.
Oh gosh, yeah. So, so with the will, again, from my knowledge,
like when do you need one?
Not so much when do you need it, but it's actually handwritten out or typed out now. I mean, how does that work?
Well, it should be typed out, notarized,
box kind of a thing.
It should definitely be in either safe deposit box or a fireproof safe, because if you die, they're going to need your will.
Right.
They won't need other documents, but they'll need your will. So you should put it in a safe or a safe deposit box.
So then the will is kept personally with you and not, let's say, at your office?
No, I don't keep people's original wills.
You just help draft them and craft them and
I'm yet to see a law firm that has like some fireproof big walk-in safe. They have like a file cabinet. And if they had a fire, you'd lose your will. I'd prefer people to keep their original documents. I've scanned copies that we could admit to court if we had to. But for the most part, you should keep your original will in your own possession. Keep it in a vault. But make sure the executor has access to it, because if they don't, then they might have to get another court order to open the box and get access.
That was literally my next question. Is that okay if the will is inside of a safe deposit box,
as long as you have
nobody
an extra
has
signatory?
If you don't have that extra signature or permission to open the box, well then
you get frozen.
You get frozen, and then you got a lot of problems from there.
Yeah.
Okay.
Absolutely.
So what are some of the tips that some of our viewers should, if they're going to think about starting a will?
Yeah.
What are some of the tips that you would give them to kind of look at either their financial assets or their family situation? What do you start with?
So we were saying this a little bit off camera. There's like two worlds of estate planning, and a lot of people think of the Downton Abbey's type of estate planning and the TV world, right? So there is tax planning that goes on to minimize estate taxes, to position your assets. But in today's world, really don't pay a lot of estate taxes. New Jersey does have about a 15% inheritance tax, but we don't have an estate tax for lineal descendants. And at the federal level right now, you have to have a net worth in excess of $25 to $30 million. And that will change if they don't change the law. That'll go in half, but it's still going to push out most of us when it comes to that kind of tax planning that you need to do. So the other side is really getting your affairs in order. So when it comes to a will, you have certain players in your will, right? You have an executor, I mentioned, the person who probates the will, deals with the court, notifies everybody, transfers the assets, appoints guardians, whatever. Then you have guardians if you have minor children, which is probably, unless you have a lot of assets, as you're growing older and you get married, that's when you should start thinking about a will.
So I'm going to jump in real quick. So the executor, who would that normally be on a?
Will probably be your spouse if you're married.
Okay.
And then it may be children if they're
Okay.
adults, siblings if you don't have
see.
children.
Okay. Got it.
Those types of things, right?
Right.
And if you run out of them, they might have to make an application to court or whatever. So they handle the whole probate process.
Right.
The guardians obviously take care of your children, and I would make sure if you have guardians that you have monies to take care of your children as well, because you're giving a big burden to potentially to loved ones to take care of your children. And then there's trustees. So especially if you have minor children, you can't leave property to them directly. We're going to talk a little bit about trusts, but you can set up a trust in your will. That would be almost like a separate bank account that's managed by a trustee, which may be the executor at the end of the day, to take care of your children's health, education, maintenance, support, and other things. I'm a big proponent, if you have the choice, of having guardians and trustees, different people, because then I can put provisions in there like cost of living adjustments for the guardian, but I can't do it if the trustee and the guardian is the same person.
Right.
Right? And I don't care how much you love each other in your family. If your sister-in-law has 3 kids and then inherits your 3 kids because you passed away, and you have $10 million in trust and has access to the money, they might think, well, what's the big deal if I pay for a semester of tuition for my kid? There's a lot of money there. But they're not really entitled to do that. So those are the kind of things that I like. So those are like the 3 main players in a will. And then there's things in there. There's things if you died simultaneously, you and your spouse. There's tax provisions. There's provisions that say we don't need a bond, because if you don't have a will, the court may make you post a surety bond to protect against the loss of the assets, things like that. There's court requirements and stuff like that. So there's a lot of that.
So a lot going on the back end of it if you don't plan for it now, and that's why this is such important, vital information that we're passing along to everybody, to get your affairs in order and do this now. And so, basic question: is there a certain age that maybe you would say somebody
I wouldn't say
start
it's a certain age. I think
or
it's
is it
more
situational?
Like, I think it's more situational.
So
if you're married, you probably should have a will.
Okay.
If you're just married, you don't have kids, and you're renting an apartment, the survivor probably could get by without a will. It's not the easiest thing, but certainly once you have children, or you buy a house together, or you have assets, you should start doing those kind of plannings. And I know we were talking about it before, but there are other documents that you should also have, probably even before that, that make sense to protect yourself and make it easier for your family when it comes to that.
Okay, so let's talk about those documents.
Okay.
What are some of them that you could pass along?
Yeah, so you should definitely have a power of attorney, appointing somebody to act on your behalf. Now, none of these documents take away any rights that you have, but they appoint somebody to act on your behalf in situations you're refinancing your mortgage or access to a safe deposit box or whatever. And there's different types. There's some that don't activate until you become disabled. There's some that are activated now until you become disabled. There's some that are durable general powers of attorney that are in force all the time. That's often between spouses. You might have a POA between a business partner, I don't know, whatever. So that gives you somebody the power to act on your behalf if you need them to. You can revoke that, obviously, at any time. The third document is a healthcare directive, often called a living will, a healthcare proxy. You'll hear it different.
Sure, I'm sure a lot of people are familiar with that.
In different states. So it has to do with really terminal illness and not being able to make decisions on your own and appointing somebody as your healthcare representative. And that gets important for children we were talking about. Once your kids become 18, and I get a lot of parents that panic when their kids are going to college because they learn the hard way. And if it makes anybody listening feel better, I learned the hard way. Like I knew about it, but I just forgot. And my son was at school and he had a health issue, and I realized when I called the health center, they wouldn't talk to me. So they need to have a power of attorney appointing you and your spouse, joint power holders to act on their behalf. You should file a HIPAA release with the doctor. So when they go to the doctor, you can get the results, and they may have their own form. And you should also have a healthcare proxy that's going to appoint you, because you don't just automatically get to take care of your children because they're adults now. So you need to have that stuff in place. And if they're going to college, usually the health centers and the bursar's office, they have their own forms too that the children should execute, the kids, or adults really at that point, should execute on your behalf to give you access to that. But sometimes people don't realize that, and then they're panicking when
something happens
and
then you
child's
need to get
in
information.
Indianapolis,
Yeah, right.
which is where my son was.
Yeah.
We can't run over and have him sign something.
Yeah.
He's across the country.
Yeah, exactly. So we were talking before we started the program about, I feel like this is a really important thing with children turning 18 and becoming legal, and just it seems like there's a lot of things that a lot of folks just completely overlook or don't even think of.
Yeah.
And what we were talking about off camera was about there's so much, obviously, social media. Kids are now turning 18 now. They've grown up with social media their entire lives.
Yeah.
So they don't know anything different. Instagram, Facebook, Twitter, Google Photos. Would that be the same situation where, let's say, if your parents wanted to look at your Google Photos or whatever, and the child could say, or not, the adult at this point, 18 or 19, could say, no, you can't because you don't have legal, it's not set up that way, so I don't have to show you.
Well, yeah, in theory, sure.
In theory,
I mean, you could say,
legally,
listen, I'm not paying your bills anymore.
Well, that's the.
But
that's
but
the
legally, yes,
yes,
the 18-year-old has the right to their own privacy under HIPAA. And if you wanted to contact Google Photos and say, I want to see their photos, they're going to say, no, you can't do that without their permission. So if you had a POA, they might honor the POA, they might not.
Right.
But that's certainly an ever-evolving area of the law. But yeah, social media. I mean, look, the younger kids set up these things, what do they call them, Finstagrams, like fake Instagrams, so their parents don't know who they are. We're not that stupid. We know what's going on.
Exactly.
But they do it, and that's because they don't have a right to privacy. When you hear about these parents where they go, I didn't know what he was doing in his room. Well, the kid's a minor. You own the house, so you have a right to know what's going on in your child's.
Exactly.
I think you have an obligation. Between
sure.
you and me.
And I think a lot of maybe again being of a certain age that you hear about Hollywood, child actors and things like that, not having access to the money because the parents were running the money, and then at 18 they want, hey, well, I want all the money that I made on X show that when I was 7,
right?
Some soap opera I was on, and I was on for 10 years, and I didn't see a dime of it, but now I want it. So that's probably. In that space where probably a lot of folks.
You get all the Jackie Coogan laws where the parents used to steal all the money from the kids. So there are things you have to do. But I think even in the case of Britney Spears, their parents had to make application to get their money in trust because once she turned of age, if you set up a Uniform Transfers to Minors Act account, an UTMA account or something like that, when they hit 18, they get the money. You might not tell them about it, but they're entitled to the money technically. It just sits there.
So now, is this another document that maybe people should look to craft, very much like a will, and keep it in a safe deposit box somewhere when their kids get to 18 and say, "Here, this is what it is," or what?
Well, I mean, possibly. I don't think 18-year-olds necessarily need to sign a will at that point. But there is probably a time to think of, even though you may have the most what's the word, the most responsible children in the world. You have a couple of $1 million of life insurance, and your 18 or 20-year-old has no concept of money and its propensity to spend, and that's one of the things that dissipates wealth. It's not like taxes. It's like propensity to spend money, divorce, and creditors. Those are like the top 3. So those are the kind of times to think about, let's say, maybe I should leave property in trust. We're going to, talk a little bit about trusts, and not directly to my children, so somebody can kind of watch over their shoulder if I'm not there to do it, right? So. And there's 2 kinds of trusts. There's one's in a will, which is called a testamentary trust. It doesn't exist until you die, and it gets set up through the surrogate's office. And then there's one called a living trust, or a inter vivos trust, the Latin term. But it's a trust that you establish now, and you get a tax ID number, and you open a bank account, and you put assets in it, and those assets get managed on behalf of maybe you. I mean, maybe your spouse, or somebody who's disabled or whatever. So there's different uses, those types of things. But they're almost like separate companies is what they are. The president's the trustee.
Sure. Okay. So now you mentioned the word trust. So let's get into that a little bit. And again, I'm a full disclosure, huge General Hospital fan. Okay. So and the reason I say that is
General Hospital in high school. I think, way back. Is it still on? I guess.
It's on. It's going strong. Yeah, it's great. But it seems like every 20-something on that show is a trust fund baby. They keep talking about, I have access to my trust fund. I get money of that. So talk to us about what a trust is and how that differs from a will, or do they go hand in hand?
Well, sometimes they go hand in hand,
Yeah.
sometimes they don't. A trust is almost like setting up a company to hold and manage assets on behalf of the beneficiaries, who would be the shareholders, and the trustee is basically the president of the company, okay? So the trustee is empowered to manage the assets on behalf of the beneficiaries. The trustee might not even be the person who set up the trust. Somebody called the grantor or the settlor, depending on what type of trust it is, but that's the person who's setting up the trust. They may be the trustee at that time, depending on the type of trust it is. They may not. They may appoint someone else to watch the assets on behalf of the child or the adult that can't manage their own assets. And there's all different kinds of, there's trust for special needs children.
Sure.
There's trust for, minor kids. There's trust for older adults who are have dementia, things like that, elder care planning type of stuff. It's all kinds of trusts. Some trusts are irrevocable, meaning you set them up and you can't take them back. And there's some trusts that are revocable, that you can take the assets back, and those are often used to avoid, probate and things like that, which is not really a big deal in New Jersey. So we're not doing those a lot in New Jersey. Sometimes we are for other reasons, but not usually. Like in New York and California and Florida, they're trust happy down there because probate's an expensive and complicated process that avoids probate when stuff.
So let me ask you, Mitch, about assets themselves.
Yeah.
What for those, who wouldn't consider something an asset? Maybe, probably most people are thinking physical things like a house, like a car, something of value to the family, a family heirloom, that kind of things. But are there other types of assets that maybe are not like physical in nature, either they're digital, or if it's like if you own rights to a copyright or something,
Yeah, sure, they
or
can
if
be
you own a
anything.
trademark, that kind of stuff?
Obviously it's the obvious stuff, right? Like your house, other real estate,
Correct.
stocks, bonds,
Yeah.
your retirement accounts, things
Right.
like that. But
Cash.
cash is definitely an asset. Gold bars, whatever you have,
Yeah.
coins, things like that, collectibles. But yeah, they're definitely nowadays, even more so than they used to be, intangible digital assets. There's these NFTs now that people own, and yeah, they all have value. They all have value. They all get disposed of. I think one of the things that people overlook, and they tend to, at least my experience has been they've overlooked, is when you're a business owner, because some of the things we were talking about when I was on last time, those things have to be addressed in a will. And you may have a separate document that addresses it between your partner, and then you want your executor, maybe your spouse, to be appointed to act on behalf and execute, like maybe a buyout or something like that, and they have to be coordinated. If you have an S corp, there's certain rules about traps you can fall into if you don't do it right. So there's a lot of coordination when you own a business, because that's an asset too.
Yeah.
You don't think of it, you're just trying to pay your bills, and you can't sell it.
Right.
But
Right.
when you die, there's going to be a value to it.
Sure.
You're going to need access to business accounts and stuff like that.
And I also think, being in the TV space, entertainment space, I think maybe going forward that, maybe a prominent thing or a bigger thing may develop is your actual likeness.
For sure.
For like AI and things like that.
Yeah, I know. They're
The
already talking
actual
about
likeness of your face, Mitch.
Right.
Who owns that? Do you own it, or does somebody else own it? And could somebody come in and take that and use it on something else, let's say 50 years from now, and have some sort of a green screen here, and you're talking to, and the AI is taking over, and we're doing this interview 100 years from now, and we're talking about something completely different, but it's your image and my image, but we're not necessarily,
I don't think it's
owners of the voice and things like that. I don't think it's even settled, even touched yet.
No, I don't think so. And probably you own your own likeness, but if you pass away, does your estate own it? How long does it does? By the way, you can't own, if you know about this whole thing with Disney and Mickey and Steamboat Willie, they're losing the trademark, I think, or the rights to the likeness just because it expired. I don't know. It's going to have to be decided, and and a lot of people are making digital assets. They're making YouTube videos. They're making podcasts. They're making
really
those are
great
assets.
point.
And although you might not be able to sell them, somebody may want to steal it and use it, and you have rights to that and so forth. So we address digital assets broadly in a will. And giving the executor the right to deal with them and so forth.
Because now that you mentioned YouTube, that also sparks another question in my mind. There are so many YouTubers out there. You have a YouTube channel.
Yeah.
Literally and figuratively. I have one as well. And there's so many that make a living off of YouTube.
Big time.
Let's say, God forbid, something happens to them, the videos still live on. And they still continue to get views, and they're still being monetized. And that's the
I would think this
thing.
channel would be left to somebody.
Right, exactly. Like, where does that money go to? Those
if
are all
they don't
things
address it, I don't know.
Yeah.
The executor or it's an administrator if you don't have a will.
Right.
I would think if they knew about it, would go after the account to gain control of it. But
that'll be
a lot
for
of
the
that
next
is
show.
ongoing. It's developing law. Yeah.
So let's kind of do a recap here. wills, we know they're very, very important.
Right.
Let's kind of run down what people should.
So if you have assets, even if you're not married,
right,
you should consider a will, because those
even
assets,
if you're single. If you
yeah, because those assets might not go where you want them to go. Maybe your parents are older and they're getting state benefits. This has happened recently for a client I was working on, and then you died. The assets are going to go back to your parents if you don't have a will and you don't have children.
Yeah.
They don't go to your siblings,
right,
unless your parents are deceased.
Right.
So it's important to have a will. Or if you first get married, time to start thinking about a will, because you and I both know you don't know when you're going to have children. It usually happens sooner than later.
Right.
So you want to get that stuff in place, and you start talking about guardians and all that kind of stuff, which always creates arguments. So those are the first thing. You also want to definitely have powers of attorney if you're married, healthcare directives, even if you're not married, appointing parents or whatever, because God forbid you end up in a situation where you're terminally ill or you're disabled in an accident, unconscious. You want somebody to be able to act on your behalf so you don't end up on tubes and they got to go to court. They got enough problem dealing with the devastating situation of your dooming death. And then they got to go to court to get an order to unplug you. It's not a situation you want to leave family in.
Wow.
So those are the kind of documents you should address.
Right.
Trusts may come later as you get older and you develop more assets. And definitely if your kids become 18, you know, healthcare directive, power of attorney, look into HIPAA releases, talk to your college, get all that stuff in place.
And also have the fireproof safe or the safe deposit.
Don't leave your will in the house where you die in
Don't
a fire
leave it under
with
the
your
mattress,
will.
right?
Not good.
So the dog can come up and eat it or something like that.
Exactly.
That's not what you want to do. All right, Mitch, again, great job. Great information on wills and trust and estate planning. Thank you so much for joining us once again here in the Channel 36 studio. Also want to say a big thanks to our creative director, Phil Scardilli, is in there switching the show for us. So thank you, Phil. The set looks absolutely fantastic. And Elizabeth Klee, our boss here, for setting everything up. So I'm Don Smith for Channel 36. Thanks for watching, everyone.